Hello and welcome to Williams Mullins Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Bryden DeWitt, and today I'll be joined by Nicole Lobbett, the Managing Director for SageView Advisory Group, to discuss cybersecurity for retirement plan sponsors. How are you doing today, Nicole?
I'm doing fine, Bryden. I hope you are too.
I am. Thank you for joining us on the Williams Mullins Benefits Companion. Today, we thought, you and I were talking about what we would talk about, and we thought, cybersecurity would be a good topic, especially in this age of COVID, where a lot of employees are working from home. They're working remotely, and they're connecting with their work, through the internet and by email, and how that impacts retirement plan sponsors. And what really, I think, brings this to light is a recent case where a participant in a 401k plan, Leventhal, filled out a withdrawal form for $15,000 from his 401k plan and provided it to his office administrator. The office administrator, however, worked remotely. She worked in another state. She worked in Texas, and apparently used her personal email account, her AOL account, to submit the withdrawal form to the third-party administrator for the plan. And that all went well. The third-party administrator forwarded the request to the custodian. They wired the $15,000 to Leventhal's bank account, and all of that was great, right? But apparently, it looks like because she was using her AOL personal account, which wasn't as secure as the work account, cyber criminals were able to get a copy of that withdrawal form and sent fraudulent emails with fraudulent withdrawal forms to the third-party administrator for withdrawals to an account that had not been used by this participant. It was a fake account, for over $400,000 from the participant's account, basically wiped out his account. So the participant and the plan sponsor sued the third-party administrator and sued the custodian for a breach of fiduciary duty for not recognizing that these weren't correct withdrawal requests, that these are fraudulent requests. And interestingly, the third-party administrator and custodian turned around and said, well, if we're at fault, you're at fault. And so they filed a counterclaim, which recently over the summer, the district court and the circuit court allowed those counterclaims to go forward, pointing the finger back at the plan sponsor, back at the named fiduciary for the plan, that they did not take appropriate security measures to prevent this sort of thing from happening. They didn't require, they allowed their office administrator who was working remotely from home in another state to use her personal email account. And so the litigation is still ongoing, but it's interesting. And I think it highlights the need for plan sponsors. There's so many fiduciary responsibilities that plan sponsors and named fiduciaries for a plan have, but it also includes thinking about things like cybersecurity. So, given this environment, do you think plan sponsors have an increased concern around the safeguarding of participant information and assets?
I do. And I know when I first read about that article, $400,000 to just kind of disappear over a few weeks was quite alarming. But you made a point earlier about, during COVID, of course, I feel like plan sponsors are under more pressure to kind of allow flexibility for their employees to work from home.
Right. And this is going to continue, right? I mean, this is the way that life is going to be even post-COVID.
Yeah. And I think all of us, and I know that's true for our office here at SageView, overnight we had to figure out how to do business somewhere else. And so I'm wondering how many other organizations that may not have robust IT teams and security protocols might have let employees to use a personal account, in the hopes of just getting business done.
Right.
And I think, I think plan sponsors sometimes, especially with a small to mid-size 401k plan with a third-party administrator like Leventhal, like that partnership had used, something like $100,000 leaving the 401k plan would have made people sit up straight and, look more closely at the distribution amount. But, again, during COVID, we have these new CARES Act. We have the CARES Act, which absolutely allows plan sponsors to make amendments and allow for coronavirus-related distributions up to $100,000. So, while some of those transactions might have been more rare a few prior to COVID, I think that they're more common these days.
Yeah, and if you think about it in this situation, the plan sponsor, the employer, wasn't seeing those withdrawal requests. So yeah, maybe the custodian or maybe the third-party administrator should have been aware and said, And that's really what Leventhal and his firm is arguing, that they breached their duty.
Right.
And they may have, right? Those withdrawals probably should have made them sit up straight and pay attention. But their counterclaim that the courts have said they can bring is that, okay, maybe we should, if we're at fault, you're at fault because you had a fiduciary duty to make sure this didn't happen in the first place. So, the employer may say, yeah, you should have noticed this, but at the same time, the employer has a duty to make sure that the communications are secure.
Yeah, and I think too, as the articles about this case have come out, it made me sit up and think through the organizations that I work with and what have they done as a committee or as a plan sponsor or fiduciaries to the plan to make sure this doesn't happen for their participants. And so, we at Sageview have decided as part of our third quarter investment reviews, we are going to make the discussion about security protocol around 401k plans an agenda item for our meetings. If a plan sponsor asked me, and none have so far, but what can we do to make sure that our participant data is secure? I think that there's a few things they could do. And none of it is fail safe, but the first thing they could do is kind of put their vendor partners on a data diet. And by a data diet, I just mean weeding out the information that you may send via email that's not necessary. So for example, as an advisor, I might want to know how many people are in a specific mutual fund. Well, it's easy for a plan sponsor just to download a report of people, socials, addresses, and send that to me, but really that's not the data. I wouldn't need all that data to come to a determination. So evaluating all the transfers of data that a plan sponsor engages in and really minimizing the amount of data that's sent probably is the easiest way and probably best way to kind of reduce their risk. I think too that, when a plan sponsor is considering a new record keeping partner and they issue an RFP, I think it's incumbent on them to make cybersecurity a core component of the questions that they ask of the record keeper and at least compare and contrast the data security policies of that firm. I think too about some of our clients who have had long-standing arrangements with their vendor partners where their agreements may not even include or address anything about cybersecurity. So I wouldn't think it's too much to ask them to go back and amend their agreements to look at adding those policies, those current policies. And also, obviously, looking for, language that indemnifies against losses, damages, or expensive lawsuits.
Yeah, I really liked all of that. I think the concept of a data diet, that's a really good concept. And in the context of health plans, especially if employers have fully or self-insured health plans, they should be familiar with the HIPAA requirements. And one of the requirements under HIPAA is that you use or disclose the minimum information necessary for the purpose of the disclosure. And that minimum necessary concept is kind of what you're talking about with a data diet. And that's a best practice, I think, for retirement plan sponsors to use that also in the context of retirement plans. And also with all fiduciary decisions, if you can document that the committee thought about data security, that was an element of when they did the RFP, that if you can show documentation showing that the committee was thinking about cybersecurity, that's always going to work in the favor of the plan fiduciaries.
Thanks for that confirmation, because as you know, there's no DOL guidance on how a fiduciary should manage their cybersecurity, but just having the confirmation from ERISA counsel that that's a good idea and what we plan to do with our clients is helpful.
Right, and borrow from the HIPAA, from the health plan side, where we have regulations on what you have to do to keep information secure.
Yeah.
What about purchasing a cybersecurity policy, and if that's a good idea, how do plan sponsors know how much protection they should purchase?
That's a great question, and just like I know you do it often. It's a basic tenet of being a fiduciary, but when you don't have that knowledge as part of your committee, I think it's incumbent on you to hire prudent experts. And so while Sageview might be is considered a prudent expert with regard to investment advice and investment management, not so with cybersecurity and IT. So I think just like they hire you or they hire us because they don't have ERISA counsel in-house, or they don't have savvy investment advisors to help them make determinations about investment selection, it'd probably be a good practice to go ahead and seek out that expertise outside the organization.
Right. So do you think we'll be seeing more cases like Leventhal in the future?
Oh, I'd like to tell you no, but I absolutely think we will. And I think to your point, at the beginning, that the fact that we're all working remotely, it makes, our plan sponsors more susceptible to cases just like this.
Right. Well, Nicole, thank you so much for joining us on the Williams Mullen Benefits Companion. That'll wrap up our discussion of cybersecurity. If you have any questions or suggestions for future episodes, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.